Hi, everyone. I'm Kim Straker, and I want to welcome you to our HR Forum event today. We have two important topics that we'll be covering. I'd like to introduce you to my two colleagues, Maria Papasavastos and Jason Silver, who will be leading our discussion today. I'll be moderating. We have a PowerPoint that we've prepared to help you follow along during our discussion, and we'll be emailing you a copy of the PowerPoint after the event. So don't feel like you have to take notes down. Maria is going to begin our discussion today by covering pay scale disclosure requirements. She'll give you an overview of the existing laws around the US, and she'll spend some time focusing on the New York City law, which will become effective on November 1st. Next, Jason will cover the current state of union campaigns, what's driving them, and the NLRB's current agenda. He'll also discuss notable rulings from the NLRB and inform you of the changes that are likely to happen. If you have any questions during these two presentations, please put them in the chat box. I'll be monitoring that chat box, and we will try to address your questions at the end of each presentation. If we can't get to all of your questions during our designated hour, we've also set aside additional time for questions in a separate breakout room that you can opt into joining at the end of our presentation. You'll see a prompt come up on your screen when we're done, and you can select which breakout room you'd like to enter, where you'll be able to ask your questions live to either Maria or Jason. If you're unable to join us in one of the breakout rooms, you can also feel free to reach out to any of us by email or phone with your questions, and we'll get back to you. Also, we wanted to let you know that we're recording this event so that we can send out the recording to those clients who aren't able to attend today. I will be announcing the CLE code later on for those of you who would like CLE credit. And with that, I am going to turn it over to Maria to begin today. Thanks.
Maria, you're muted.
Anything now?
Maria, now we can hear you.
Okay, so sorry about that.
Okay.
What I did say
from the top again.
So thank you all for joining. As Kim mentioned, I'll be covering these wage range disclosure laws that seem to be all the rage these days. You've probably heard a lot about these laws that are passing across the country. A lot of jurisdictions are considering passing these types of laws, and it's really becoming a patchwork of different laws that employers are expected to comply with coming up very quickly. So as Kim mentioned, we're going to be covering a lot and getting into more details with the New York City law, but I also know that many people on the call today have national operations. So I wanted to give a general overview looking at the big picture and how the New York City law will play into other jurisdictions as well. So starting off here right now is a list of the current jurisdictions that have wage range disclosure laws in place. And again, big picture, these laws really fit into three buckets. So you have the laws that require upon an applicant or an employee's request that you provide wage range information. You have another bucket that is at some point during the application process or the employment process that there's an affirmative requirement to disclose wage range information at that time. And then you have the jurisdictions in the last bucket, which is those that require wage range disclosure within a job posting or within a promotional opportunity notice. And the ones that fit into that last bucket, it really started out with Colorado that has far-reaching implications for employers with requiring disclosure in the job postings, as well as in promotional opportunity notices that are required to go to your Colorado employees. And Colorado really started out with requirements with, if you have one employee within Colorado, you are subject to this law. And certainly with COVID and remote work and considerations about a lot of workforces becoming remote, the implications have become broad. And I mention that because New York City has really followed suit with Colorado with requiring that for remote positions that can be performed in New York City, you need to comply with the law. So big picture, these laws might be focused on specific jurisdictions, but they do have far-reaching implications for companies' operations throughout the country. So here are the breakdown of the pay scale disclosure laws that require disclosure upon request. And the caveat for California and Washington State is that these are the current laws in effect, but you may have seen that as of at least 2 days ago, Governor Newsom in California has now approved the California amendment. So California will now switch over to the bucket of the states that require pay scale disclosure in job postings, as will Washington State. So as of January 1st, 2023, this will change. But under the current status of the laws, it's Maryland, California, Ohio, Cincinnati, and Toledo in Ohio, and Washington State that require that if an applicant or an employee, depending on the law, requests pay scale information, then the employer must respond and provide that information. The next bucket that I mentioned was those that require an affirmative disclosure at some point during the process. So that would be in California, for example, if prior to or at the time of an offer of compensation, employers have to affirmatively provide wage range information to the applicant. And in terms of what must be provided, that varies as well by jurisdiction in terms of what must be provided. Generally, it is, when you define a wage range, it's usually base salary as a wage range, but there are separate requirements for what might make up the wage range and what that can be dependent on. For example, you see the language here for Connecticut. So really pay attention to what must be provided in these laws, as well as the timing of when they must be provided. Moving along, we have this newest trend in requiring wage range disclosure in job postings. So California, as of January 1st, will require a pay scale to be provided in the job posting. It will also expand the law so that for current employees who request wage range information, employers will have to provide that information. Under the current law, it's only if applicants request it. Again, you have the Colorado requirements, which are very far-reaching, and the separate promotional opportunity notice requirement, which is a bit tricky because the Colorado agency defines a promotional opportunity very broadly. It doesn't only include those who are qualified for a promotional opportunity. You have to provide notice of all positions that could be a promotion in terms of advancement within the company, a greater salary, regardless of whether the person is qualified for the position. So those requirements are tricky in Colorado and should be followed. We then have Jersey City, which is another one that requires the minimum and maximum annual salary or hourly wage in the job posting. There is a pending bill in New York State. It's been approved by the Senate and Assembly, and it's pending governor action. We anticipate that the governor will sign it, and it will in fact become law. So that's another thing to keep in mind as you're considering rolling out the New York City, your job postings to meet the New York City requirements, to also keep in mind that you are also complying with New York State. There is also within New York, Ithaca and New York City and Westchester County that have separate requirements to disclose pay minimum amount, maximum salary within the job posting. And Washington State, as of January 1st, will also have that requirement. So diving into the New York City law, what it states is that it will be an unlawful discriminatory practice for an employer or an employment agency to advertise a job posting, promotion, or transfer opportunity without including the minimum and maximum salaries for such position in the advertisement. It applies to employers with 4 or more employees, and that is 4 or more employees globally or nationally, as long as at least one employee is located within New York City. It does not apply to job advertisements for temporary employment at a temporary help firm, as there's different requirements under the Wage Theft Prevention Act for disclosing pay information. So the New York City law does not change those requirements for temporary help firms. So after the initial New York City law was passed, there was an amendment to the law. You may have noticed that the effective date of the law was, it was supposed to be back, I believe it was in July, and it got pushed back to November 1st of 2022, so coming up very quickly. The amendment clarified that the law does not apply to positions that cannot or will not be performed, at least in part, in the city of New York. So this part of the amendment was as a result of confusion as to how the law would apply for remote positions and for positions that maybe there's a company outside of New York City and hiring employees within New York City. So there was a lot of pushback about how does this law apply to us? And this was the response from the city. So while it's stated in the negative, what it means is that if the position can be performed in New York City, whether that's remote or in a physical location, you must include the wage range in the job posting. The amendment also clarified that the law applies to employees who are paid both hourly and on a salary basis. So if it's an hourly wage, you would include the wage range for at that hourly rate. The amendment also limited the availability of a private right of action to employees bringing claims against their current employers. So applicants cannot bring a private right of action under the law as amended. And this was the result of pushback that there would be a flood of lawsuits from applicants applying to a bunch of jobs and be able to bring lawsuits then. The amendment also specified that civil penalties will be $0 for the first violation if the employer proves that the violation has been cured within 30 days. An important caveat here, though, is that the law states that if you are found to have violated the law, even if you cure within 30 days and you don't get a penalty, you will still be considered to have violated the law for if there is a subsequent violation as well. So what we're thinking here is that this was kind of the commission's compromise, so that if someone makes a mistake the first time or and cures it and attempts to comply with the law, but then they again violate the law, the commission would probably be able to impose higher penalties than if it was just a first violation. So the New York City Commission on Human Rights also put out a fact sheet on the law to kind of give a bit more guidance. And some key takeaways from the fact sheet is that, again, I mentioned this earlier, that the employee threshold is 4. It includes owners of companies, but the 4-employee threshold is nationwide, so long as at least one employee works within New York City. Again, the law does not apply to temporary help firms. However, employers that work with temporary help firms must disclose salary ranges in their job postings. So that temporary help firm exception does not apply to the employers who work with the temporary help firms. It also specified that advertisement is a written description of an available job, promotion, or transfer that is publicized to applicants, regardless of format. So they're considering advertisement to be pretty broad here. There's also no requirement to create advertisements to hire. However, if an employer chooses to advertise, the advertisement must include the salary range. So there's no requirement to post your promotional opportunities if you don't already do so, which is a distinction from the Colorado law. And there's no requirement to post external job postings. However, if you do choose to do so, you need to include the range. The salary range, there's a bit more clarity in the fact sheet as well, that it means the lowest and highest salary the employer in good faith believes it would pay to the successful applicant at the time of the posting. So that at the time of the posting language is important, because you may post a position and have a good faith belief of what you're going to be paying someone who's coming into the role. But maybe your needs change. Maybe you have a candidate who comes in who has much more qualifications than you were expecting. And at that point, what we have heard from the New York City Commission is that it's okay to go above the range that you've posted or below the range that you've posted, so long as it was a good faith estimate at the time of the posting. And this is also consistent with guidance from Colorado. So New York City seems to be following that similar guidance. The commission fact sheet also specifies that the law covers postings for any remote work that could be performed in New York City. So again, this is an expansive reach. If you're posting a remote position that can be performed anywhere, it must comply with the New York City law. It also specifies that good faith means the salary range the employer honestly believes at the time of the posting that they're willing to pay the successful applicant. So your salary range should be what you're actually willing to pay the applicant. The salary range also cannot be open-ended. So it cannot be $15 per hour and up, or maximum $50,000 per year. There truly has to be a minimum and maximum provided. The only exception is if there is truly no flexibility in the salary that you're going to be offering. So if it's just $20 an hour for the job, you can indicate that rate only. You also only need to disclose the base salary or wage rate for the New York City law. Salary or wage rate does not include benefits, paid or unpaid time off work, contributions to a 401k, overtime, anything like that. It's strictly the salary or the wage rate. Of course, employers could decide to include more information in their advertisements if they, for recruitment purposes, want to specify that you can provide a bonus, or that there will be certain benefits provided to their employees. It's absolutely fine to include that. It's just not a necessity. So potential exposure and penalties under the law is that a violation will be treated similar to any other discrimination claim under the New York City human rights law. There is a private right of action limited to employees bringing claims against their current employers, so not applicants. And employees can sue for back pay, front pay, compensatory damages, punitive damages, and injunctive relief. Applicants or current employees can file a complaint with the New York City Commission on Human Rights. The penalties available are $125,000 to not more than $250,000 for a willful violation. But again, the civil penalties will be $0 for a first violation, with the intent really being for getting companies into compliance with the law and not having a punitive penalty right from the beginning. And that's kind of what the commission has said its goal has been in pushing out this law. The Commission on Human Rights could also order changes to certain job advertisements and policies and practices as part of any violation that's found, and potential remedies that could be provided. So There's also these laws in Ithaca and Westchester County that are also requiring a minimum and maximum salary range. So they mostly track the New York City law on the general requirements. It's a minimum and maximum salary. There's a good faith requirement for the range, and temporary help firms are excluded. Some key differences with Ithaca is that it does not apply to an employer that employs fewer than 4 employees whose standard work locations are in the city. So it's more of a city focus. It also doesn't include the provisions added to the New York City law through the amendment, which was that 30-day cure opportunity. And the Ithaca law was effective on September 1st of 2022. So that one's already in effect. For Westchester, that one includes a provision from an earlier iteration of the New York City Amendment. So the earlier version of the amendment that was being considered excluded help wanted signs or similar communications. So the Westchester law included that into its law that actually passed. It also includes any employer who posts for positions that are required to be performed in whole or in part in Westchester County, whether from an office, in the fields, or remotely. The Westchester law says that it will become null and void on the day that the statewide legislation goes into effect. So the Westchester law will become null and void, but that's not the case for New York City. The Westchester law will become effective on November 6th, 2022. So the New York State law, a quick overview, it will require employers to disclose in the job posting compensation or a range of compensation and the job description. It specifies that advertisements for jobs, promotions, or transfer opportunities paid solely on commission will be compliant if they make that statement. If they disclose that the compensation will be based on commission, that's sufficient under the New York State law. It also applies to job postings that can or will be performed, at least in part, in the state of New York. So that's similar to the New York City requirements. And there is no private right of action under the New York State law. A person can file a complaint with the commissioner, though. It also includes an explicit no retaliation provision and a record-keeping obligation. The penalties under the New York State law is civil penalties up to $1,000 for a first violation, and then they go up from there. There is also expected to be rules and regulations and a public outreach campaign once the law is actually passed. And it will become effective 270 days after enactment. So once the governor takes action, it will go into effect 270 days after that. And a key point about the New York State law is that it will not supersede or preempt any local law, rules, or regulations. It specifically says that in the law. The only exception would be the Westchester County law that includes its own provision on the New York State law and it becoming null and void. So a quick point about some takeaways with all these laws. I think a key point in considering this is to first develop a compliance strategy. And this will really depend on what your organization's goals are and what its strategy is overall. What does your organization want to share? When does it want to share it and to whom? Do you want to go above and beyond what the laws require? Or do you want to keep it focused on the specific requirements of the laws that are currently enacted? There is also the consideration of the impact of certain laws across the organization. So, and this relates also to the administrative burden versus the culture on transparency. Some companies that I talk to regularly have said that it's just too much of a burden to try to continue to update our postings to comply with these laws, or to tailor our postings and to go into the system and try to tailor them to specific jurisdictions. So they may choose to have more transparency overall. They may include job wage range disclosure in all of their job postings to make sure that they are compliant with the jurisdictions that require it. And this may also depend on where your operations are. Do you have a lot of employees in New York City? Do you have a lot of operations in California where the law has just passed? And if so, maybe it makes sense to avoid that administrative burden and to have more transparency generally. There should also be considerations of your pay ranges and taking a deep look at how you're defining pay for different positions. Do you currently have pay ranges? And if not, do you need to create them across the organization? And are your current pay ranges for current employees different from what you're willing to pay new applicants who are coming into the role? And are there any other relevant considerations that are unique to your specific business? And in terms of kind of implementing these laws going forward, it's important to make sure that all of your hiring managers, your talent acquisition professionals, HR employees are trained in the requirements of the law. I've worked with a lot of companies on preparing talking points or FAQs to try to make sure everybody is on the same page for what to do if they are asked about a wage range for a particular position, or if an employee asks, why is the job posting range different from what my range is? Why am I being paid at the bottom of the range? All talking points and guidance for your leaders on how to handle this. You could also create templates for responding to requests to make that process a bit easier, and templates for making those proactive disclosures to your employees. So you know that at the time you have to make an offer of compensation, you have to provide wage range information. So perhaps you make a template where every time you hire an employee, you have this document that goes to everyone. There's also developing job posting language based on that strategy and running that by your legal counsel. And overall, just a few additional points about proactive pay analyses. It's super helpful to conduct this kind of deep dive into your pay so that when you're posting ranges, again, questions may come up from your current employees. Why am I being paid at the low end of the range? Why are you paying somebody who's coming in so much more than what I'm being paid? And that could certainly raise concerns with equity within your organization. So you want to consider this as you're rolling this out and make sure you're finding the best way to have those conversations. And then going forward, do you have a system in place for evaluating compensation on a routine basis? Are you looking at comp ratio? So looking at someone's compensation in comparison to the midpoint. Are you doing internal peer reviews upon hire? Are you doing a peer review at promotion? And consider each opportunity of pay and how best to evaluate. So that includes bonus and equity as well. And it's really making sure you have systems in place going forward for your equity and ensuring that you're not creating an imbalance there. So that's it from me, and happy to answer any questions anyone may have. I know we might be short on time.
Great, thanks, Maria, thanks. A few questions we'll just briefly go over here, and then additional ones can certainly be brought up in the breakout room session. But do these new laws apply only prospectively to new postings? Or if a position is still open and it was posted, like let's just say with the New York City law, if it was posted prior to November 1st, do you have to repost it and now include salary ranges?
So the commission has said that it's not retroactive. So if you have a position posted before November 1st, that's fine. However, if that posting is refreshed, or if you make any changes to the posting, then the commission recommends that you then include the salary range in that posting that was changed after November 1st.
Okay, great. So if you don't change the post, then you don't have to do anything to comply.
Correct. I guess the only other caveat would be if it's a longstanding position, a longstanding posting that's you keep in effect for a long period of time. I would probably update those as well.
Okay, great. Now, how can multi-state employers comply if a job posting can be filled by a remote worker almost anywhere in the US? I mean, you kind of talked a little bit about this, you know, kind of maybe adopting a broad transparency strategy, right? But, you know, what kind of guidance can you give? Like, are they required to state the exact range for every location where, you know, it can be performed? I mean, how would you handle
Yeah,
that?
so there's a couple ways that you can handle it. Some have more risks than others. I think generally for remote positions, when you're posting a remote position that can be performed anywhere, I'm generally more comfortable advising that the position, the range that you're providing can include different geo differences because it's a good faith estimate of what you're actually going to be paying for the position, depending on different factors such as skills, education, experience, and that also includes where the candidate happens to be located and any geo differential in salary for that individual based on their location. So I think for remote positions, it probably makes sense to have that broader range that includes different geographies. For positions that can be performed at specific locations, I think there's more risk in doing that because what you're in good faith going to be paying somebody in California is probably different than what you're in good faith going to be paying somebody in Colorado. So it gets a bit more tricky defining that. I have seen some companies try to list out the salary range by jurisdiction, saying if this position is performed in Colorado, then this is the range. If the position is performed in New York City, this is the range. So there's a few different ways you can structure it to try to comply and make it as least burdensome as possible.
Okay, that's helpful. Another question, on one of the slides, you talked about the laws not applying to temporary help firms, but then you stated that employers that work with temporary help firms must disclose the salary range in their postings. Can you just kind of clarify that distinction?
Sure. So the temporary help firms would be, they'll be providing the salaries and they'll have their own obligations as they are hiring people to perform work at an organization. Whereas the employer, if they have a position that might be filled by a temporary help firm in part, or if they're reposting a position, or if they're separately looking for candidates for the same role, then they would not be subject to an exception like that.
I got it. Okay. Okay. And if you're hiring at a salary range outside it, well, I guess the question is, can you hire at a salary range outside of the ranges that are posted if you're not in New York City or Colorado?
So that's unclear based on any kind of guidance. I think that given the good faith language in a lot of these laws, probably. And I think that a lot of the states and jurisdictions are looking to each other for guidance as these things are rolled out. But that's not clear based on any guidance in any other jurisdiction yet.
Okay, great. Thanks so much, Maria. And if anyone has additional questions, please join Maria in her breakout room session after we conclude. But right now, let's turn it over to Jason for his very important topic.
Thanks. Maria, if you could just stop share. Perfect. Thank you. Everybody see that PowerPoint up there? Okay, excellent. These past few years have certainly been an exciting time to be a practitioner in this space, as we've seen the pendulum of case law kind of move back and forth, depending in part on the makeup of the NLRB, which is derived from the political party in power in this country. And we've also seen an increase of organizing activity in this country, and we're going to talk about both of those now. So during the first 9 months of fiscal year 2022, union representation petitions filed with the NLRB have increased almost 60% from its 2021 year-to-date counterpart. In fact, in May of 2022, petitions exceeded the total number of petitions filed in all of the previous year. So we've seen a drastic increase this past year of unions filing petitions with the NLRB to have elections for employees to decide whether they want to be represented by a union or not, and whether they want the union to act as their official spokesperson with regards to their terms and conditions of employment. At the same time, we've also seen an uptick and an increase in unfair labor practice charges filed. These charges are filed by either an individual or a union, alleging that the employer is doing something that violates the National Labor Relations Act. We've seen an increase this year from last year at around 50%, at around 15%. So two things that we're going to kind of focus in on now is with regards to the increase in organizing activities, where we're seeing this increase and what are some of the factors that we believe lead to the increase. So we're seeing a lot of different types of organizing activity in a bunch of different industries, and a lot of what you see on the news and hear on the news and read, on the internet and in papers, you'll hear me reiterate the same here. So we've certainly seen an uptick in union organizing in the retail space. Starbucks, which everybody's familiar with, now has about 150 stores that are unionized, and that continues to grow as the weeks and months pass. We have Trader Joe's, we have large retail giants like Amazon. We've seen a significant uptick in organizing activity in those spaces. Also in the tech sector, Google, Apple, Glitch, another industry that's ripe for organizing activity and one that we've seen increase this last year, including media as well. The New York Times, Condé Nast, NPR, all media entities where we've seen an increase in organizing activity by employees. And probably an additional one that may surprise some of us on this call is not-for-profits. We've seen a significant increase in organizing activity at not-for-profit organizations, various institutes, centers, and foundations across the country. And the number of students graduating from university-level nonprofit management programs is growing fast, and it's expected to increase about 20% between 2019 and 2029. And another not-profit space that we're seeing organizing activity increase in is charter schools, particularly here in New York City. I represent a few charter schools, and I feel like every few months you hear of a different charter school in New York City being subject to organizing activity. So another space that we're seeing it in. And we're also seeing it in the political space. Various candidates who have staff, employment staff. We've seen an uptick in those employment staffs organizing activity and filing petitions as well. Really interesting when you're looking at what are the unions that are filing these petitions, and I think it's really twofold. We have your main players, right? The one that everybody is kind of familiar with, your Teamsters that have a national and historical presence, your Teamsters, your UFCW, the United Food and Commercial Workers, the retail workers, the RWDSU, the Communication Workers of America, the CWA. These are all unions with national and historic presence, and we're seeing these unions organize these industries as well. But what we're also seeing is an increase in independent units associated and founded and compromised of current employees, particular to that particular employer. And these unions are not affiliated with any one of the big players that I mentioned before, or even the AFL-CIO. And a couple instances and examples of that is the Amazon Labor Union, ALU, Starbucks Workers United. That's a union created by current Starbucks workers specific to organizing at Starbucks. With Google, we've seen it with the Alphabet Workers Union. So we've seen a really interesting increase in these independent unions that are not affiliating themselves with international unions with national and historical presence and notoriety. And instead, we've seen the creation by current employees of these independent unions that are trying to organize just the particular employer at issue, whether it's Amazon, Starbucks, or Alphabet Workers Union. And in that line, I think we've also seen an increase in organizing activity based on the international influence. I think the increase in organizing activity is not subject or is not focused or confined solely to this country. I think we've seen it throughout Europe and throughout Canada as well. And I think that's having an impact on the organizing activity here as well. So now that we've kind of talked about where we're seeing the increase in organizing activity, let's talk about what we're seeing in terms of factors that we think are kind of causing this. And I think what we're seeing is a combination of cultural, social, economic, and political factors that is really driving campaigns and driving organizing activity. One of them is younger workers. The reality is I saw a Gallup poll that came out at the end of 2021 that provided that anywhere from 50 to 75% of adults aged 18 to 34 support unions. I think what we're seeing is a younger generation that supports unions, supports organizing activities in a way that we haven't probably seen since the 50s. So that's certainly a driving factor, a younger workforce and a younger workforce that is supportive of unions and labor institutions. I think it's a combination of traumatic events that have happened recently over the last few years, a combination of events that have had significant impact on health, on mental health, on economic well-being, COVID being one of them, obviously, shutdowns, restrictions, uncertainty outside and inside the workplace. I think in 2020, we've seen, layoffs as a traumatic event. In April 2020, the number of laid off employees was 18 million, which I think reflect the immediate impact and effects of the COVID-19 pandemic at that time. Moving ahead to 2021, I think that was the year where we continued to see some COVID restrictions throughout this country. And we also saw resignations occurring in very large amounts. And in fact, in November 2021, the resignation rate reached a 20-year high. And now looking forward to 2022, we've seen inflation. Consumer prices are up 9.1% over year end in June 2022, and that's the largest increase in 40 years. So it's a combination of these traumatic events that have an economic impact as well as a social impact that we think is also driving some of these campaigns and organizing activities. And along with that is activism, social justice agendas, whether that's voting rights, climate, healthcare, racial injustice, gun violence. What we're seeing is unions are affiliating themselves with these causes, and they're affiliating themselves with individuals who support these causes. And what we're seeing from the activism space is, again, an uptick in younger individuals taking up those causes. And when you're talking about younger workers, the reality, like we mentioned before, is that we're just seeing more so now than in the immediate past, an uptick in the younger generation who support traditional labor and who support unions. So what else? Workplace justice initiatives, right? The recent successful public campaigns of the Me Too movement or the pay equity movement or the wage disparities to the mega wealthy. Again, these are issues that are very important to the younger generation. And these are issues where unions are aligning themselves on these issues and thus aligning themselves with the younger workforce and younger workers. Politics. Now, so more than ever, we have politicians standing with unions. The reality is this president has on multiple occasions stated his intention to be the strongest pro-labor president ever. He ran on those campaign pledges, and everything that he's stated and he's said in his agenda that he would like to accomplish would support that. So I think that's also a significant factor, being that we have the president being one of the most pro-labor presidents in recent past, leading this drive as well. And the last one is fame. The reality is that press is everywhere. The reality is that social media is everywhere. And the need for a constant news story can be monetized by people, whether that's for social reasons, for appearances, and the like. So we think these are some of the bigger factors that are kind of leading this organizing effort and leading this organizing activity. And what we've also seen in 2022 is it's kind of been the year of walkouts, strikes, and strike threats. According to the Labor Action Tracker at Cornell University, strikes in 2022 so far have significantly outpaced strike activity in 2021, with 180 strikes involving almost 80,000 workers occurring in the first 6 months of 2022, compared with just 102 strikes and 26,000 workers in the first 6 months of 2021. And the reality is that walkouts and strikes and threats of strikes are being utilized by folks in an effort to make gains in terms and conditions of employment. They're using these type of tactics to try and put pressure on employers and, in an effort to try and make gains in terms and conditions of employment. And I think we've seen in the news all sorts of stories of strikes and walkouts and strike threats, whether that's at various stadiums, whether that's Activision, museums, railway workers, teachers, nurses, at Starbucks, at Amazon. It's turning into the year of significant labor activity in terms of whether it's walkouts, strikes, or strike threats. So what do we do with this information, right? How can we make sure, given that what we know that what's driving the increase, and we know where those increases are occurring. So what can we do? And I think it's more important than ever to stay connected to and invested in your employees and the culture of your workforce. What are we doing to stay engaged with our workforce, and how are we treating people on a professional and a personal level? So I always like to tell people to ask yourself these 4 questions, right? Am I showing an interest in the things that mean the most to my people in their personal lives? Am I taking an interest in their livelihood, both personal and professionally? Am I checking in informally with each of my people every so often? Right, when you check in every so often, it's very easy to establish a relationship where it's very clear that you care about somebody and that you're concerned about their well-being professionally and personally. Am I taking the time to listen to the concerns my people are raising and then explaining the reasons for my actions or senior management's actions? The reality is oftentimes employers make some decisions that some employees don't sit well with some employees. That's just the reality, and it's our job to take control of that communication and clearly delineate to our folks the rationale and reason for certain decisions that we're making. And that last one is, am I doing the fundamental blocking and tackling of appreciation? Am I saying thank you? Am I saying please? Am I making sure that people understand that I appreciate their efforts, that I'm treating them with empathy, that I'm treating them with care, that they feel like they have a voice in the organization? And if you're not asking yourself these 4 questions and you're not doing these 4 questions, what is your plan to change them? Because I think anytime you talk about organizing activity and anytime you talk about unions in general, these 4 questions help lay out a plan for how we should be treating our folks and some of the things that we should be doing in order to make sure we're answering these questions in the affirmative. Okay, so now that we've kind of gone over organizing activity and the increases in that, we're going to talk about the NLRB General Counsel's agenda, what that agenda entails, what we're seeing that has changed, and more importantly, what we're seeing that we think is going to change in the future. So the General Counsel of the NLRB is Jennifer Abruzzo. The General Counsel is independent from the board, and it's responsible for the investigation and prosecution of unfair labor practice cases and for the general supervision of NLRB field offices in processing cases. And the reality is the NLRB GC has a large hand in deciding what cases get prosecuted and what cases ultimately come before the NLRB. And general counsels release what's called guidance memos. And while guidance memos are not binding authority, they're certainly helpful in that they provide intel on some of the issues, areas, and case law that this general counsel is going to look to take up with the NLRB. And as you can see there, with regard to Jennifer Abruzzo's philosophy, at the bottom of that screen there, it's no mistake that she's made it very clear that she's seeking vigorous enforcement of the act, and she's trying to expand and ensure employee rights in the workplace. So let's look at some of her memorandums and some of the areas that she's going to be looking to change and kind of see where they've gone and where we think they're going to go. So one of the first memorandums she issued, she signaled a desire to change a multitude of facets of law under the NLRA. First being employee handbooks. Cases involving what's called the applicability of the Boeing standard, which was implemented in 2017. And at that time, it imposed a new framework for determining the legality of workplace policies and handbook rules. And the Boeing standard allowed handbook rules to be evaluated not only on the basis of legality under the law, the NLRA, but also on the basis of the employer's justification for that policy. And that standard more easily allowed employers to tailor their handbook rules to the specific needs of their workplace. General Counsel Abruzzo has made it very clear that she wants to reconsider the application of Boeing to employer rules governing employee confidentiality, non-disparagement, social media, communications with the media, civility rules, respect and professional manner rules, offensive language, no cameras in the workplace, and no recordings in the workplace. So I think employers should expect additional scrutiny on those particular workplace policies in the future, and you should exercise caution when issuing discipline for violation of any of those policies as well. Second area that she's signaled a desire to change is protected concerted activity. Protected concerted activity is a cornerstone of the NLRA. That is when 2 or more employees or 1 employee speaking on behalf of a group basically are allowed to come together and raise concerns related to their terms and conditions of employment with their employer. What General Counsel Abruzzo has made very clear is that she's trying to expand what constitutes protected concerted activity. And in fact, in an interview she gave in Bloomberg on December 7th, she defined protected concerted activity as including social justice, economic justice, and racial injustice advocacy. We're also talking about with regard to protected concerted activity using employer email systems for purposes of engaging in Section 7 rights or organizing activity. We've also seen a desire to change existing laws on union access rights, expanding unions' access rights to particular employers' property, In specific, whether off-duty contractor employees are allowed to be on a property where they are working to engage in organizing activity or other Section 7 rights. She's also signaled a desire to take on employee status, particularly independent contractor, and what standard and burden should be used to ascertain what is an independent contractor under the NLRA. And that's very important because if you are an independent contractor under the NLRA, you're not an employee, which means you're not covered by the Act. So she's looking to take up that particular issue as well. The applicability of Weingarten rights in non-union settings. Weingarten rights is a cornerstone of Section 7 activity, and essentially it's the right of union represented employees upon request to have their representative present during an interview that the employee reasonably believes could lead to discipline. This has historically been a union represented right, and what we're seeing and what we're hearing is General Counsel Abruzzo trying to extend that particular right into a non-union setting. There was a case that came out a few weeks ago that we'll discuss a little later that kind of implicates that. Another area that she's looking to change is laws around intermittent striking and picketing. Mainly, how do we define what's called an intermittent strike, what would qualify as unlawful secondary activity, and whether employers can unilaterally set terms and conditions of employment for replacement workers that are above and beyond what striking workers currently make. What are some other memos and kind of topics that she's looking to take on? That first bullet point, mandatory submission to advice. Cases and subject matter areas where the Trump board overruled legal precedent. Some of the topics that I mentioned in that last slide, employee handbooks, confidentiality provisions, separation agreements, protected concerted activity. Cases that involve these that were decided on the Trump board are now being submitted to advice to see if that's, instructing regions to consider those cases and see if we need to rebring those topics up before the board in separate cases. What else are we seeing in GC memos? We've seen the GC's desire to increase the utilization of what's called a 10J injunction proceeding. As a brief background, Section 10J of the Act allows the board to seek temporary injunctions in federal court while cases are being litigated. These are typically sought once an employer has committed or followed through on its threat to terminate a union supporter or take other adverse action. What she's doing is instructing regions to potentially seek injunctions, 10-day injunctions, prior to an employer following through on its threats or coercion. But immediately after determining that workers have been subject to the threats, but before employers follow through on those threats. She's also looking to seek full remedies and impose a variety of remedies in unfair labor practice cases and in settlement agreements that we have not seen before. In addition to your general back pay and make whole remedies, she's also contemplating consequential damages for individuals who've suffered other economic losses, such as healthcare expenses, or credit card late fees, or missed car payments, or missed mortgage payments. These are other types of damages that she's considering imposing as a remedy in cases where employers have violated the National Labor Relations Act. Student athletes. Student athletes have historically not been defined as an employee under the National Labor Relations Act. That's a topic that she's seeking to take up. She believes that there are certain college student athletes that are employees under the National Labor Relations Act, which means that they should be entitled to the protections of the National Labor Relations Act. And another big one is the elimination of what's called captive audience meetings. For decades, the NLRB has permitted employers to hold mandatory employee meetings during paid time, wherein a company representative is speaking to employees and talking about the topic of unionization and the company's stance on unionization. And what General Counsel Abruzzo is looking to do is make those captive audience speeches unlawful to the extent that the employer does not make them voluntary to attend. So even though they are paid and unpaid time, she's looking to make the attendance of those meetings voluntary. And if an employee voluntarily selects not to go, that employee cannot be subject to discipline. Aside from memos, there's also a rulemaking process. Aside from GC memos and NLRB cases, we also see changes in case law through rulemaking through the NLRB. And on September 6th, the board issued a notice of proposed rulemaking that will replace the current joint employer rule that took effect under the Trump board back in April 27, 2020. Now, under that rule, an employer could be a joint employer of another entity only if it had direct and immediate control over the essential terms and conditions of employment of the other entity's workers. Under the proposed rule, 2 or more employers would be considered joint employers if they share or co-determine those matters governing employees' essential terms and conditions of employment. So in a nutshell, under the proposed rule, joint employer status would apply when 2 or more entities simply have the ability to control employment terms and conditions, not necessarily that they're exercising that particular ability. There's also various rulemakings for election protection in the context of union elections. So the ability of pending unfair labor practice charges to block the election process, the impact of an employer's voluntary recognition of a union to subsequent representation proceedings, and the formation of collective bargaining relationships in the construction industry. And these are standards that were similarly amended in favor of employers during the Trump administration through the rulemaking process. So likewise, if the NLRB creates new rules on these topics, we're expecting the pendulum to shift back in favor of employees. So as far as, we've gone over GC memos, we've gone over rulemaking. What are some notable rulings from the new NLRB? And the reality is we're going to cover 2, but there haven't really been that many yet. Regions are developing test cases that they want to send to the board, and amicus briefs are being solicited by parties for cases currently at the board. But there are 2 cases that have come out recently in the last few weeks that I want to go over quickly. The first one is a Tesla case in which the board ruled that dress codes and uniform policies that prevent employees from wearing pro-union apparel of any type, even if the rule is facially neutral. So even though it doesn't appear to be discriminatory on its face, if it bans any type of union apparel, it's going to be presumptively to be unlawful, which means that any union insignia donned by an employee, no matter how big, distracting, or gaudy, is protected, unless the employer can demonstrate what's called special circumstances justifying the regulation of that activity. Some special circumstances would be safety, quality control, public image, and the like. So employers should be aware that this decision affects both union and non-union workplaces. And in light of this decision, should kind of review their written dress code policies and ensure their current policies and handbooks do not interfere with the right of employees to wear or display certain union material in the absence of special circumstances. And the second one that we're going to talk about, it's called Troy Grove, and it relates to Weingarten rights. And it was very factually specific. And the specific issue in that case, the board was deciding whether the replacement workers that were brought in by an employer during a strike enjoy the same Weingarten rights as their unionized striking employees. And in that particular case, the board concluded that they do. And as a lawyer, it would be very easy to limit that, the rationale of that case to those specific facts. That's normally what we would do. But for General Counsel Abruzzo's, proclamations that she's looking to extend Weingarten rights into a non-union setting. So this case did not do that. It was very factually specific, but I think the takeaway from this case is that we should very, very soon anticipate that particular issue, whether Weingarten rights are extended into the non-union setting, is going to be decided by the NLRB. So quickly, some likely changes that are going to come. Just overviewing some cases that are out there and some cases that we think the board's going to want to take a look at again. Dealing with confidentiality and arbitration agreements, whether employers are allowed to maintain, to require maintaining confidentiality of arbitration proceedings, including the discovery process and hearings. Implementation of employee handbooks. You've heard me talk about this one at the beginning. This is going to be a big one. What standard should be used when we're evaluating facially neutral policies? What standard should be used when we're evaluating non-facially neutral policies? Is it the Boeing standard? Is it something else? This is something that we think the board is certainly going to take up. Investigation of confidentiality rules. In Alcoa, the board held that the employer did not violate the NLRA when its labor relations specialist told workers that their interviews in an investigation into alleged employee misconduct were confidential. Whether that is going to be the case going forward is presumed to be seen. What constitutes good faith bargaining, and how far can an employer engage in what's called hard bargaining before the board takes a position that that's unlawful? And again, workplace rules, handbooks, and policies. That AT&T mobility case dealt with a case whereby the company barred workers from recording conversations with their colleagues. Certainly a case that we think the board's going to be interested to take up, including any social media postings and social media policies as well. And then just a few more potential changes that we've seen with the granting of amicus briefs. And again, an amicus brief is where an individual organization who is not party to the legal case is permitted to submit a brief or a stance by offering information, expertise, or insight on that particular issue. So we're going to cover 4 or 5 amicus briefs that have been solicited really quick. The first one being American Steel Corporation. This has to do with what is the appropriate standard to use when you're talking about what's the appropriate unit petition for. Is it that standard that you see there called PCC structurals? Is it a standard that was imposed before that called specialty healthcare, whereby under specialty healthcare, it made it very, very easy for unions to go after the smallest subset of employees possible? Atlanta Opera, that has to do with the independent contractor status. What standard should we be using to determine independent contractor status? Whose burden should it be on in establishing that? And then Stericycle as well. We've kind of covered this one as well. But again, another instance where the board is looking to overrule the Boeing rationale and standards with regard to determining workplace violations and what standards should be used. And then the last 3 more cases. Sunbelt Rentals, that has to do with Johnny Poultry statements in an investigation and whether Johnny Poultry statements should be continuing to be used as a safeguard for employees, or if we should be considering a different, more robust standard. The second one being one of, certainly a topic that everybody's familiar with when they see Scabby the rat outside of on the sidewalk or outside of an employer's workplace. Does the display of Scabby the rat or a large similar banner constitute lawful picketing, or is it otherwise unlawful secondary picketing? And then that last one, Ralph's Grocery Company. So whether confidentiality requirements in a mandatory arbitration agreement violate Section 8A1 of the Act. So we've gone over a lot of different kind of cases and the agenda of the NLR, of the General Counsel, rulemaking, and then some of the cases that we're looking for the board to take up. So what should we be doing? I think it's important for us to all stay up to date regarding NLRB developments, rulemaking, and decisions. I think anybody who practices in this space is a bit surprised that we have not seen more cases published up to date, but we're certainly aware of the topics that the NLRB is looking to take on and the topics that the General Counsel is looking to take on and change. And we're going to have to understand how those decisions impact your company and your workforce, and likely have to revise those workplace policies and employee handbooks as required whenever those decisions come out or whenever rulemaking comes out. And in that regard, we would just advise to engage outside counsel periodically for assistance. That's why I'm here. That's why we're here, to answer any questions that you have. We're certainly monitoring these developments on a day-to-day basis. And like I said at the beginning of this presentation, it's certainly a very exciting time to be in this space. And it's a very unique area of the law in that every 4 or 8 years, when we see a presidential party in power change, it could potentially mean a drastic change in NLRB case law and how the NLRA is enforced and interpreted. And with that, that's it for me, Kim. So I'm gonna give it back to you.
Great. Terrific. Thank you, Jason. So just in the interest of time, because I know that we're a few minutes over our time, I am going to announce the CLE code. I also put it into the chat box, but it is SS, like as in Seyfarth Shaw, 1247. Again, SS 1247. And right now, we will conclude and go into the breakout room. So if anyone has questions for Jason, please enter his breakout session, and questions for Maria, please enter her breakout session. And thank you so much to everyone